Ladies and gentlemen, I'm going to call this meeting to order for the Standing Committee on Justice and Human Rights, meeting number 46. And it is a televised meeting, and the orders of the day we have, pursuant to the order of reference of Friday, June 20th, 2014, Bill C-32, and Act 2, I don't know what's in my ear here, and to enact the Victims' Bill of Rights and to amend certain acts. And appearing before us is the Honourable Minister Peter MacKay, the Minister of Justice and Attorney General. And just before we go to the Minister, everyone has on their table the budget from our review of the prostitution bill that was here before us in the summertime. We had allocated $39,900 at the time. We are just slightly over that. We got one more bill, I think, or just came in. So we have approval for $39,900. We are asking for approval for another $5,000 just to make sure we cover everything off. It's been moved. All those in favor? And that's carried. Thank you very much. Okay, with that, thank you, Minister, for joining us. We're here to talk about C-32. As you know, the floor is yours for 10 minutes.
Thank you very much, Chair. Colleagues, je suis heureux de comparaître devant ce committee.
I'm happy to appear before this committee today to speak about Bill C-32, the Victims' Bill of Rights Act, which will create the Canadian Victims' Bill of Rights and entrench the rights of victims into federal law.
Victims of crime has been a key priority for our government since 2006, and I appreciate the support that has been received for this bill thus far at second reading from a numerous group of stakeholders, victims advocates, including members present since the bill was tabled last April. This bill reflects broad consultations, input received from over 500 stakeholders in person or online, bringing forward reforms discussed at every federal, provincial, territorial fora, and best practices from international, provincial, and territorial legislation and programs. So there has been a tremendous amount of input. At its core, the Victims' Bill of Rights complements existing measures for victims of crime while respecting constitutional divisions of power in the administration of justice and mindful, very careful to avoid causing undue delay in the criminal justice process, which was an important consideration, I can assure you, raised often during our consultations. I strongly believe, Mr. Chair and colleagues, that this bill strikes the appropriate balance between victims' rights and accused rights, and importantly extends rights for victims at every stage of the criminal justice process, from the beginning of the investigation to the consideration of the release of the offender on warrant expiry. It affords victims a true sense of inclusion, of respect, and consideration throughout the process. The proposed primacy clause stipulates that all federal legislation would be required, to the extent possible, to be interpreted in a way that is consistent with the Canadian Victims' Bill of Rights. Where there is a conflict between the federal law and the Bill of Rights, the provisions of this bill would prevail, with certain notable exceptions. Victims will benefit from general rules that will be entrenched, will be spelled out, will be cast in federal law for the first time. We know that victims of crime often seek information about the criminal justice system and the role that they play, about their case, about the decisions made by the justice professionals throughout the process. This bill creates a right to information. It brings amendments to the Criminal Code, Corrections and Conditional Release Act to provide more information to victims on things such as bail and prohibition orders, plea arrangements, victim offender mediation, the parole board decisions. This proposal builds on existing laws, policies, and best practices. Nous savons que les victimes recherchent une protection.
We know that victims seek enhanced protection measures in their interactions with the criminal justice system. Bill C-32 would build on numerous current provisions in federal law to better protect victims.
Statutory scheme governing the disclosure of third-party records in sexual assaults proceedings in the testimonial aid provisions would require courts to consider the particular security needs of victims or witnesses. Similarly, proposed amendments to the Canadian Criminal Release Act would allow the parole board to impose reasonable and necessary conditions on an offender serving a long-term supervision order. which would include a non-contact or geographic restriction if the victim presented a statement about the safety before the board. Studies on child victims have shown that publishing identifying information can exacerbate trauma, complicate recovery, and discourage children from reporting crimes to the police or impact on their cooperation with authorities. That's why the proposals relating to publication bans involving children and using pseudonyms are the logical next step in enhancing victim protection in our system. The amendment on spousal immunity has sparked some interest. The proposed amendments would ensure that if a spouse has relevant evidence to give, the Crown will not be able to call the spouse to testify. Bill C-32 would not, however, change the privilege regarding marital communication. A married person testifying in a trial may still refuse to disclose a communication made to them in the confidence of the spouse during their marriage. Nous savons que les victimes souhaitent une participation.
We know that victims seek to be meaningfully involved in the criminal justice system. The right to participation proposed in this bill would recognize that important concern.
Broaden the scope of the victim impact statement provisions in the Criminal Code would clarify that victims would be permitted to speak to the emotional, physical, and financial impacts of the offense in their victim impact statement. And it could also include them taking a photograph with them or use testimonial aids to present their statement to the court. These are compassionate measures that we think will aid in the ability of a person to give their evidence. We know that victims are also concerned about the financial impact of the crime, which often places them in serious hardship. The amendments proposed would provide victims with the right to have courts consider restitution orders against the offender, as well as the right to enforce orders as civil judgments, which could possibly or would possibly avoid lengthy civil proceedings for the victim of crime. We know as well, Mr. Chair, that victims were seeking enforceable and practical measures to address the harm and prevent similar harm to others. And I must pause for a moment to just pay tribute to those very courageous individuals who took part in this process and helped with the presentation of this bill by sharing their experiences in the criminal justice system. For many, it was a very painful experience to go back over what had happened to them, but I know that they did so with tremendous compassion in their hearts in the hopes of preventing victimization in the future. During the consultations, many victims advised that they did not want to see police or prosecutors impeded in the exercise of their authority or punished. They simply wanted organizations to address problems up front and spare other victims and their families some of the unfortunate experience that they had. The proposed remedies approach would provide remedial action to victims more quickly than any external adjudicative process and make federal departments and agencies proactive in addressing victims' needs. This remedial scheme provides a review mechanism with statutory powers, operational expertise necessary to assess potential breaches of victims' rights in the context of each department's or agency's operations, requiring that victims use existing oversight bodies with authority to oversee the operations of a department or agency. This is a cost-effective and timely approach, and it's consistent with the input that we received during consultations. Plusieurs défenseurs des droits des victimes au Canada.
Many of Canada's leading victim advocates have expressed clear support for this proposal to create enforceable rights for victims. The Federal Ombudsman for Victims of Crime, in her first report on Bill C-32, stated that it is a significant step forward in helping to acknowledge and enshrine victims' role in the criminal justice system. This is very positive.
Allow me for just a moment to touch on some of the elements that the bill won't address. The bill doesn't propose to make victims a party to the criminal proceeding or give standing, nor does it give victims the right to receive automatically legal aid. These are areas which we spent a great deal of time considering and reviewing. We believe that we received significant feedback during the consultations on these specific suggestions, and many, I might say, were concerned that it could lead to unintended negative consequences for victims, unnecessarily burden the justice system, and lead to significant costs and delays in criminal proceedings. For these reasons, We have not proceeded in that direction. The bill also does not give rise to a cause of action or claim in damages. Criminal justice officials noted during the consultations that imposing additional civil liability on officials responsible for implementing this bill would impact on the operations, cost, and functioning of the justice system. As similar clauses appear in provincial and territorial victims' rights legislation, other federal statutes, and related statutes in other countries, we are confident with the approach that we've taken on this issue. This bill will also not provide victims with a right to review or veto a Crown decision to prosecute. Again, we've received tremendous input on this subject. Prosecutorial discretion is a constitutionally protected principle in our criminal justice system, and we are protecting it under Section 20 of this bill. However, we have included amendments to the Criminal Code which would require the court to inquire if the Crown had informed the victim of any plea arrangements for serious personal injuries offenses, which we believe strikes the right balance and the right approach. Our focus here is giving victims consultation and a voice at a critical point in the criminal justice process without creating undue cost or delay, or in any way undermining what we feel must be a balance in a fair trial. Nous continuerons de travailler avec nos partenaires provinciaux.
We will continue to work with our provincial and territorial partners to implement this legislative measure.
It's my hope that we will continue to work together at the federal level to ensure that this bill does, in fact, restore victims to their rightful place at the heart of our criminal justice system. I thank you in advance for the work that you're undertaking in reviewing and looking at this bill in detail. I thank you for your diligence on a number of legislative agenda items that you have before you, and I look forward to your questions.
Well, thank you, Minister. Thank you for coming. We are going to go to questions now. You are joined by two officials from the Department of Justice, Madame Mornessi. I don't know what's wrong with this thing. It's driving me crazy. Director General and Senior General Counsel for the Criminal Law Policy Section, and Madame Arnott, Director and Senior Counsel Policy Center for Victims Issues. The floor is now over to Madame Boivin for 5 minutes.
Merci, Monsieur le Président. Merci.
Thank you, Chairman. Thank you, Minister, for attending this meeting to present your vision. In the case of Bill C-32, the Canadian Charter of Victims' Rights, at the very outset, I would like to say that I am quite happy to see that it was possible to accelerate the study of this bill in committee so that we could have examined this bill. I think it is very important for us to look after the people that we represent, and among all our constituents, of course, there are victims of all kinds, victims who are defined in various ways. I am quite happy to see that we are going to looking at a good many. We're going to having a good many meetings to examine this bill. I'm happy to hear you, and we'll be hearing mainly from victims, people who are concerned with victims' rights, people who deal with victims in the legal context and other contexts. And we intend to focus on this issue because very often we have the impression that the justice system is not on their side and tends to forget them. And I think that this is an important way of rebalancing the issue. You talked about consultation. My first question for you is because there will be many people involved in applying this legislation, this charter, once it is adopted. Our partners will be the territories and the provinces, and I'd be curious to know whether you did consult the provinces. How would this consultation take place? They were made aware of this bill. Were you able to discuss specific measures with them? Do you have any specific information to give us about how this will be implemented and applied? Yes, of course, and thank you, Madame Boivin, for your comments and your question. We certainly did have an opportunity to discuss matters directly with certain provincial justice ministers at the meeting last fall in Whitehorse. We did have consultations with individual provinces and territories. In the case of Prince Edward Island, for example, the Minister of Justice did take part in this meeting.
To bring as many people into that process as possible, not only our provincial and territorial partners, but many of the organizations who are involved in the frontline delivery of services for victims, of course lawyers, prosecutors, even some judges who were consulted. I should mention as well that there was an online consultation, one of the first that we've undertaken, and it actually led to a larger and even more inclusive consultation that took place with respect to the response in the Bedford case. So I would suggest to you that this was an effort to hear from as many perspectives as possible, but most particularly, and with emphasis as you suggested, on victims themselves and hearing their experiences.
Talking about the victims, the Ombudsman of Victims, which is doing exceptional work, sometimes with limited means, and she's not paying me to say that, but je suis curieuse de savoir le rôle que vous allez...
I'd be interested in knowing what type of role you see being played by the Victims Ombudsman based on the Victims' Rights Charter. Will the Ombudsman have an increased role? Has this been decided yet? What type of role do you see being played by the Ombudsman in the application of this Act? First of all, you were quite right. The Ombudsman is certainly an exceptional person with a great deal of experience in the criminal justice system. And it is clear that she is playing an extraordinary role in the enforcement of victims' rights. But of course, at the same time, it is necessary to understand that the other elements do have a role to play. In the case of the RCMP, for example, there is a complaints mechanism. And the intention in this bill is not to duplicate what is already being done. And it's important to respect the role and the competence of the provinces, the jurisdiction of the provinces.
Question and answers. And my next questioner is Monsieur Gauguin from the Conservative Party.
Thank you, Mr. Chair. Merci, Monsieur le Ministre de Comparaître. On est toujours plaisir de vous accueillir. Merci également.
It's a pleasure for us to have you with us, and I'd like to welcome from the department and thank you for the work that you have been doing to ensure that our victims' rights are respected in the legal system. We know that victims are often propelled into a system that they cannot quite understand, and it is very difficult for them to find their way. And I think that the rights that you are defending here are important. Can you explain to us how this legislation will actually change the experience of victims in Canada? It is, I think, a fundamental change in approach, is it not? Yes, and thank you for your question, and thank you for the work that you've been doing as part of this initiative and for the justice agenda in general. It is, in fact, a paradigm change. At the various levels.
For the first time in federal law, these rights for victims, you will see a culture shift, and it is our hope, bring about a greater sense of accountability throughout the system, a greater recognition of the role that all the various players within our justice system must do to include victims and reach out to them and ensure that they are in fact aware of their rights and aware of the obligation that exists, whether it's from the time of the investigation. The very first contact is most often with the police, as Mr. Wilkes can attest, to that very first court appearance, to officials within the justice system, and throughout the process, from sentencing on through the process of corrections and release. And so entrenching these rights very much gives victims a greater sense of where they belong, what their ability is to in fact ensure that their rights and their role are being respected, and have remedy and have a place to go when things go wrong, which sadly they do. So it will take time to take hold. This effort, I believe, has been met with tremendous enthusiasm. It has been met with some trepidation on the part of some within the system. But I think as it is understood and as it is put in place, it will bring about what I believe will be a very positive change for victims in Canada.
Thank you, Minister. I noted your remarks that C-32 actually reflects much the input of the stakeholders that were consulted, and I note that there was extensive consultation and that this outreach was very important in coming to the final provisions that have been proposed. I also noted your remarks with regards to the effort made to respect the constitutional jurisdictions of the provinces, and I wonder if you could elaborate on the extent of the consultations which were undertaken.
Well, it was actually the very first undertaking that I made after being sworn in as Minister of Justice. I was advised by my department that I should pack my bags because I was going to every province and territory to meet with provincial representatives, to meet with many different advocacy organizations on behalf of victims, victims themselves, criminal justice professionals, territorial officials, non-governmental organizations I mentioned. We met, I should point out, with First Nations communities, representatives of Métis and Inuit organizations. We heard some heart-wrenching stories, Mr. Gauguin. I think you'll recall in New Brunswick, we heard from individuals, and I know that many of you have had similar experience, we heard from individuals who were feeling, and used the expression often, re-victimized as a result of what had occurred. And there were many different elements that this bill attempts to address, but many included lack of information, or somebody had not given them proper information, or not advised them of a decision that was being taken that very much impacted on them. They were not given information in some cases about the release of an offender. In one instance, I recall vividly a woman telling us that she had met the person who had sexually assaulted her in the line at the grocery store. And this brought back such horrendous emotions and fears and anxieties. And so it's my sincere hope, and I think you will all share this, that we will, to the greatest extent possible through the enforcement of these rights, prevent that re-victimization or sense that the system has somehow failed them. There is no perfect filter to which we can prevent every failing, but I do believe that this bill will bring about tremendous improvement, as I said earlier.
Okay, thank you very much. Thank you for those questions and those answers, Minister. Our next questioner from the Liberal Party of Canada, Madame Bennett. Welcome, by the way.
Thank you. Thank you. If the Minister has any say on the makeup of this committee, we would hope that maybe the Minister would think that there should be some women representing the Conservatives on this, or maybe some Indigenous representation. But anyway, I digress. On this bill, I guess our ongoing concern is that any bill that enshrines rights needs to make sure that there's funding to ensure that the rights are well known and able to be exercised by all Canadians. And so I think that we also want to make sure that the mechanisms in victim services are consistent across the provinces and territories, and particularly with First Nations. So I guess I would like to know what funding will come with this bill to make sure that people across Canada know about it and that the mechanisms are in place to deliver the intent of the bill.
Thank you very much, Ms. Bennett. The makeup of this committee, as you know, is not done at the direction of the Minister of Justice, although I do know that there are female members who have attended. With respect to the funding, in addition to the $120 million in the Victim Fund that was introduced by our government in 2006, there have been specific funds earmarked to enhance victim services at the provincial and territorial level. With respect to funding attached to this bill, there will be funding. It was set out in last year's budget confirming that there will be more resources made available, especially, as you point out, for the online and broader communications of the implementation. because rights, as we all know, are only as good as a person's understanding and ability to exercise them. And so it's my hope that in addition to that effort to communicate about this new bill, that the coverage of this committee hearing and the inclusion of many victims and victims groups and advocates who will appear before this committee, that will also spread the word about the improvements within the criminal justice system. So there will be more details forthcoming on the funding attached specifically to this bill, and for both the communications and the enhancement of victims' rights and victims' services across the country.
Okay. As you know, Minister, this bill has been sort of hailed as a significant component of the action planning on missing and murdered Indigenous women. From coast to coast to coast, we've heard from the families that they haven't had the support or the ability to navigate the system, and that, you know, quite rightfully, many of them have had a distrust of authority, that it is, from colonization to racism and other barriers, they don't feel comfortable in the system and complaining, and so they, I think, require some special care. I was concerned that the AFN felt that there hadn't been sufficient consultation with Indigenous stakeholders on this bill, and other than the online comments, I was wondering if you could let us know what consultations, and maybe even table with this committee the list of consultations with Indigenous stakeholders, including what you heard and how you think this bill deals with the concerns articulated in those consultations.
Sure. Well, I wouldn't take issue with what you said about the often very difficult experience that those in the Aboriginal community, First Nations community, have experienced over the years in the criminal justice system, and their disproportionate representation in terms of those who are incarcerated, those who are affected by violence. But to come back to your question on who I met with specifically, in Yellowknife we met with the Dene First Nation representative, the Native Women's Association of the Northwest Territories, the Quillette Nunavut Status of Women Council, the Kimivac Women's Shelter, the Paktuit Inuit Women of Canada, Quikatani Inuit Association, Métis Nation of Ontario, Giganu Transition House, the Mi'kmaq Confederation of Prince Edward Island. This was during the summer roundtables last year. You mentioned the online consultation. There was also input that we received.
Would you table just the specific concerns that were raised by those particular participants, and then how you think they're addressed?
Sure. We can provide sort of a synopsis of the feedback that we received there. As far as the investment that is, I suppose, providing some linkage between the Victims' Bill of Rights and what we're attempting to do as far as investment for Aboriginal women and girls and violence against them, there is a program of $25 million over the next 5 years, aimed specifically at programming both on and off reserve to assist in deferring the violence and obviously the suffering that's been experienced in the community. An action plan to address family violence, and I know as a member of that committee you're aware of those efforts.
There's some concern that...
Okay, last question, make it short.
Yeah, the Gladue principle may well be weakened by this bill. Have you had consultation about that, and could you let us know, I mean, whether this, again, will be in conflict to contradict the Gladue principle?
Well, we have contemplated that, and as you know, the Supreme Court has stated that courts are required to consider the imposition of restorative justice. I had some experience previously as a prosecutor in the early days of restorative justice and things such as sentencing circles. So I believe in the principle. I believe that they do work in some instances. However, there's also, of course, the ongoing need to balance those considerations when there is serious violent crime and sexual violence against individuals. And so all of that is going to be considered by the judge This is where the final determination will be made, and how to calibrate the application of the Gladue principle with other considerations such as the victim's background and the victim's experience to that point that led them to find themselves, in many cases, in the court as a victim. And so we have to bring those sentencing principles in line when it comes to the final determination, but ultimately I have great confidence in our judiciary to make good decisions in balancing out those existing precedents with what we believe is contained in the Victims' Bill.
Thank you very much for those questions and answers. Our next question from the Conservative Party is Mr. Decker.
Chair and Minister, thank you for being here today. And I want to say I was really pleased to see the introduction of this Victims' Bill of Rights. I've had the opportunity to speak to victims of crime in my city of Mississauga and across Canada, and so many times I've heard, you know, we suffered the assault, I suffered the harm, I made a statement to the police, and I heard nothing further until maybe I was called to trial one day and treated like just another witness. And I didn't know what was happening in the investigation, I didn't know what was happening in the prosecution, and yet the harm was done to me or to my family. And you mentioned in your opening statement that the Victims' Bill of Rights contains a right to information. And that seems, from what I heard, and I want to also say that I had the opportunity to serve on the Special Committee on the Violence Against Indigenous Women, as Ms. Bennett did, and we heard from some of those victims, the families of those victims, and this was a key concern of theirs, that they hadn't received information both about the investigation into what happened to their loved one, and when there was a prosecution, someone was charged, they got very little information about the whole prosecutorial process. I wonder if you could tell us a little bit more about what the right to information means in this bill and how it would make a difference to the life of victims.
Well, thank you very much, Mr. Deckard, and I know you and many members of this committee did, in fact, take part in the consultation and in the formulation of the bill itself. And like you, this was one of the glaring shortcomings, if I could put it that way, is that basic information was sometimes missing for the victim, and it caused a profound sense of exaggerated harm and uncertainty and anxiety, particularly when court dates were changed and there was no explanation given, or, as I spoke of earlier, an offender may have been released back into the community without proper notice. And in many cases, I truly believe that this is never done with any sense of malice or even done out of error. There is sometimes a genuine disconnect where one department or one individual may think that somebody else has already informed the victim. We heard this often during the consultation. The police thought the Crown had informed them. The Crown thought Victim Services had done so. And so what this bill, I believe, will accomplish on the information piece is to clarify people's roles, to bring about greater certainty of responsibility in the sharing of information, and to the greatest extent possible, provide that victim with the firm understanding of the guarantee to the information which they're entitled to. Information that can include now such things as court orders of restitution, court orders of the conditions that attach to the offender upon release, for example, in a bail hearing. Things now that will include such thing as a picture, a recent photograph, a recent image of the individual if they had been incarcerated for some time. Information in some cases where the victim is registered with the Corrections and Conditional Release of how the offender has responded to treatment, or whether have they expressed remorse. These are sometimes things of great importance to the victim, to know how the offender has responded, or whether they have sought treatment, whether they have demonstrated an effort to rehabilitate themselves. So this bill sets out to the greatest extent possible and delineates what information should and must be made available to the victim upon their request.
I do believe this Victims' Bill of Rights will help to restore the faith of Canadians in the criminal justice system, which I think is very important. You mentioned the right to safety and security. That's very important. We hear that from victims, especially victims of assault, all the time. Can you tell us a little bit about the right to safety and security measures that are in the bill, and in particular this right to access a recent picture of the offender before release?
Well, I think suffice it to say that there is few things that would be more important to a person than to be able to recognize or pick out the person who caused them harm, and where periods of time have lapsed or the individual may in fact have made deliberate efforts to change their appearance, there is, I think, a right that an individual should enjoy to be able to take whatever necessary steps to protect themselves. The very least is to be able to identify the offender. As far as other steps, that knowledge of what those conditions of release may be, whether it be earlier in the process, during, for example, pre-trial, pre-sentencing, or after release, the conditions that the individual has to adhere to, including stay-away orders and certain conditions that would apply directly to their residence, to their children, to their place of work. That type of information being relayed accurately and in a timely way to a victim is extremely important. And I might add, practically speaking, this does happen for the most part. Much of what we are entrenching in this bill is done regularly and routinely across the country. This is meant to bring together and consolidate a greater flow of information and a greater flow of confidence to victims and to those in the system and to the public at large, as you've just said. But I wouldn't want this to ever be construed as a damning criticism of those who are working hard in the system every day. But this is all about ensuring that we're doing everything possible and everything now through a federal bill that will bring about greater compliance and greater protection for victims overall.
Okay, thank you. Thank you very much for those questions and the answers. Our next questioner from the New Democratic Party, Madame Mouvin.
Is that c'est vrai que
it is, of course, difficult to be against Bill C-32. There are certain critics who have spoken out against this bill, particularly its binding or non-binding aspect. It would appear to be good statements of principle in some respects. For some people, these rights already exist in certain provinces. There may be bills of victims' rights. The federal government did have a type of charter in 2003 with the provincial and territorial partners. The question that I'm often asked, and I'm sure that must have been asked you as well, I'd like to know what your answer is. How is this Bill of Rights, this Victims' Bill of Rights, C-32, binding? Because there are 4 important sections in this bill out of 60 clauses. You talk about the right to information, the right to protection, the right to participation, and the right to compensation. But which of those provisions are, in fact, actually binding, legally binding? We do not see many of them. And what the victims say is that they're happy to see that there is a certain recognition. But there are not many definitive arrangements here. They're worried about funding, for example. How many programs were cut back in the past years, programs that were aimed at providing help to victims? I met representatives of First Nations groups that had programs to provide assistance to victims in their communities who presented such programs, and all of them were turned down. It's rather difficult for people to believe in the reality of this. They are distrustful to a certain extent, and I can understand why. So I'd be interested in knowing what your answer would be to this type of a reproach. Many provinces already do have this type of Bill of Rights, and they would be the ones responsible for applying them. Thank you, Madame Boivin. You are right. There are similar bills in all of the provinces and territories.
In federal law, puts in place a system that is meant to enhance and protect victims' rights in a way that truly places victims' rights on a level that is consistent and fundamental with all other federal legislation within our criminal justice context. And so
You enforce it. How will you make sure that it's applied uniformly in Quebec, in Ontario, in Newfoundland, and so on and so forth, when you're not in charge of the administration of justice, and when the courts already have problems with access to justice and so on?
Well, the immediate enforcement and the mechanisms which that'll be achieved will happen over time. This won't be like flicking a switch. It will require some adaptation. It will, what I would suggest, put in place greater linkage between those other complaint mechanisms and the Federal Victims Ombudsman's Office, which is a relatively new insertion in our criminal justice system since 06-07. That office will allow for oversight and will, I suggest, over time develop a working relationship with those other mechanisms, those other complaint processes at the provincial and territorial level. There is also, to come back to your question about funding, there is increased funding from the federal level into things such as the Aboriginal justice system, into further victims advocacy organizations, most notably, and I would suggest, Madame Boivin, if you have had the opportunity or not had the opportunity, please visit one of these child advocacy centers. This is perhaps one of the most innovative insertions of victims' rights that I've seen in my lifetime, as far as getting young people the type of help and support that they need at the very front end of the system, which reduces victimization for them at that tender year stage. So I would suggest that there is...
I do wish we could export that program and that way of doing things to so many others, because to this date, from your own ministry, or your own department, it shows that it's still pretty much 80% of the cost, of the total cost of victims are really, comment est-ce qu'on pourrait dire, c'est les victimes elles-mêmes qui...
It's the victims themselves who are the ones that bear the major costs.
There is very important change happening through those victims advocacy centers for children that can be imported into the adult system. So these improvements are happening. It does obviously always require resources, but the best part of this, and what I'm really pleased to see happening, and I think you would agree working within the system, is the incredible dedication of the people who are devoting their time and effort to child victims in particular. And that is what is making the difference. It is the tremendous professionalism, lessons learned over many hard years for victims, that we are seeing the type of change in the counseling and the programming, the early intervention, the lessening of trauma, particularly for children, and those mechanisms that were in place but weren't being always uniformly used. Testimonial aids, for example. Something as simple as allowing a child to take their pet to a police interview or to a court appearance so lessens their anxiety and their negative experience. So those things, those important steps forward are being made, and I think will be translated across many other victim services.
Thank you very much. Thank you for those questions and those answers. Our next question from the Conservative Party is Mr. Wilkes.
Minister, for being here today. I'll center my questions around restitution. And if I may, Mr. Minister, I'll just give you the 4 questions I have, and then I'll let you just carry on. So, first of all, can you tell us what restitution is? There's a lot of people that probably don't understand all of the restitution that can be involved. And why does the Victim Bill of Rights include a right to access restitution? 2, why is restitution important for the victims? 3, why are these changes so important within the bill? And 4th, if a restitution is made in favor of the victim, what mechanisms are in place for non-compliance?
Okay, thank you very much, Mr. Wilkes. Those are really important questions, and restitution, simply put, is part of the sentencing order to allow the victim to be, to the greatest extent possible, repaid or put back in a place that they would have been had the crime not occurred. So restitution actually is an effort to cover losses, whether they be financial losses, property losses that have been experienced. Now, where this becomes difficult, some would say impossible, is trying to restore any psychological or physical harm experienced by a victim. But that's where counseling and deferring medical costs is part of a restitution order that can be made for the court. Losses must be calculated. They must be able to ascertain or calculate what that loss is in order for a judge to make an accurate restitution order, and it must be directly attributable to the crime. So that, in a nutshell, is what restitution is. As far as why is it important, it's part of the healing. It's part of the sense of true justice that they are given acknowledgement and restitution for their loss. And so it's a very important principle within the justice system. We heard a lot during the consultation from individuals who felt that the offender didn't truly appreciate the impact that it had on them. And restitution is a form of rehabilitation as well, I would suggest, that the offender is giving back and trying to put the individual back in the place they would have been had they not been harmed. Victims often talked about the out-of-pocket expenses throughout the process, that they were required to commute back and forth to the courtroom, they had missed work, they had to make child care arrangements, they were out of pocket. It was costing them further. It was as if the crime continued to be committed, was ongoing. And so restitution is a very important part that we felt necessary to ensconce in the bill and to bring about true effect for the victim and to bring about changes that would help at least blunt the impact of the crime in terms of the financial and sometimes psychological impact and physical impact that victims experience. Why is it important that we do this, or why were these changes necessarily included in this bill? Well, it's already part of the criminal code. It's our hope that this will bring about greater enforcement. What are the mechanisms to do so? This will empower courts, we believe, to follow through, to make, in some cases, necessary adjustments. And I'm going to go out on a bit of a limb here in suggesting that there are some provinces who should look at their victim fine surcharges, to look at alternative measures programs that can be put in place that will give the victim a greater sense of satisfaction, so that there is efforts to see true compensation and restitution. And there is, of course, also civil remedies that can be put in place as well that will allow for greater compliance with these restitution orders. So it's a long answer to 4 specific questions, but we felt that restitution is a very important part of a victim's right throughout the entire process, and we think this will give it greater teeth.
Thank you very much. Thank you for those questions and answers, and I'll plug that. Our next questioner from the New Democratic Party is Madame Péclet.
Merci beaucoup, Monsieur le Président, et merci beaucoup.
Thank you, Chairman. I'd like to thank the Minister as well. The discussion that we are having today is a very interesting one, and I think that it is a necessary discussion. The main obstacle for victims in the justice system at the present time, and this is not something that I've come up with on my own, there was a report produced by the Canadian Bar, as well as a study that was carried out by the Chief Justice of the Supreme Court on access to justice. There are various organizations that have examined the question of access to justice, and one of the problems is delays. And this is probably the main hurdle in obtaining justice for victims. We've heard of a number of cases where, for example, where the accused, where the procedures were delayed for an unreasonable amount of time, and the Supreme Court has been examining this concept because there are so many pressures on the justice system at the present time that the Supreme Court has to determine what can be considered to be an unreasonable delay in the present state of affairs. Providing a list of rights, and I think that you will agree with me on this, in Bill C-32 is a very voluminous one. There are all sorts of rights that are being recognized, and there's a great deal of pressure brought to bear on the agents in the justice system. But what is going to be done? Because there's a flagrant lack of resources, there are unreasonable delays, and access to justice is extremely difficult. I realize that there's an attempt to allow victims to play a more important role, and they're certainly entitled to this, but how will this be possible in view of the fact that they may have to wait years and years to see justice, and in fact, they may not ever get access to a lawyer, they may not have enough money. I think that you are aware of all the practical problems. So I'd like to know what you intend to do to implement this bill. This was a question put to you by my colleague as well. How will you ensure that all the provinces do have the necessary resources to implement these rights? Because at the present time, the claim is that they don't have enough resources or the time.
Implementation, and I'll come back to the fact that, as I said earlier to Madam Bennett, we do have funding attached to the bill for implementation and for ensuring greater awareness, in particular to victims, but at all levels, provincial, territorial, and non-governmental organizations. As far as the question about this contributing to further delays or backlog or exacerbating the issue of access to justice, I can assure you that we carefully balanced all efforts and all that you see entrenched in this bill with that in mind, and as a backdrop to every calibration that we were making to insert or perhaps assert victims' rights, we were always mindful that anything that was going to cause further delays or restrict a person's access to justice, or perhaps more appropriately, a fair outcome, was always present in our thinking, because it is counterintuitive to what we hope to achieve through this bill that it would actually cause delay. Because delay, it goes without saying, is one of those old maxims, delay is the deadliest form of denial. That's what victims had often complained about, is that from the initial reporting of the crime to an outcome, whether they were satisfied or not, it was this prolonged, torturous process. And so for things such as consultation with the victim on a decision that a Crown Attorney has to make, or a police officer communicating that, it's my hope that this is actually going to accelerate the thought process throughout to communicate these things to a victim in a timely way. It's going to bring about, I believe, a greater sense of obligation on the part of everyone in the system to consult with that victim early and often. And it's important to understand, and I say for emphasis, that victims were not asking for a veto. And there was a report. I sat where you're sitting as a member of the opposition when these discussions were happening years ago, and there was a report produced by a predecessor committee called A Voice, Not a Veto. And it underscored that victims were not saying, look, we want to be able to stand up in court and state our case in addition to what the prosecutor says, or we want our own counsel. Some may advocate for that, but the vast majority of victims are simply saying, we want to know that our voice matters, that we've been heard, that we are being given meaningful right and access to justice throughout the process. I don't think that necessarily means slowing things down. I think it actually will help streamline in some cases, and I think there is tremendous commitment at the provincial and territorial level, who are at the front end of the delivery of many of these services, to see that that happens. If it requires more resources, we're prepared to do that, as long as they're prepared to say, here's what it's actually cost, and here's the bill.
Thank you, Minister. Thank you for those questions. Our final question of the Minister this afternoon is from the Conservative Party, Monsieur Lazon.
Thank you very much, Chair, and welcome, Minister. It's certainly a pleasure to have you here. Minister, I can attest to the efficacy of and just the wonderful work that these child advocacy centers do. I have the good fortune of having one in my riding, and I just can't believe what they're doing for our youth, for our children, and the legal system, the justice system, the police, from police officers up, are so impressed with the impact it's having on our children. It's really nice to see. Having said that, I would just encourage your department, any way you can promote the expansion of these centers right across the country. Is so meaningful to our children. With this Victim Bill of Rights, it just happened that Monday morning before I came to Ottawa, I had the occasion to meet 4 constituents in my office. And believe it or not, 2 of them had been victims of crime. 2 out of 4. Just happened that way. However, the ramifications of being victims in their particular cases, and these are adult men, both of them were adult men, it's devastating to see what being the victim of these 2 crimes did to these people. So I can't encourage you to continue this more than that. But my question is maybe you can expand on the right of participation, and maybe tell us a little more about the specific changes that might be brought about by the Victims Bill of Rights.
Firstly, Mr. Lauzon, I'm familiar with the Child Advocacy Center in your area in Cornwall, and it's one of the best, as I said to you previously. And we do have intention, I should say. We have 20 now operating in the country, or in the process of being fully operational. And it has been, in my view, again for emphasis, one of the most important innovations that we've seen in decades in the criminal justice system. And it's important to keep in mind, and I'm sure members of this committee are aware, that that is one area where crime rates are not falling. Child sexual abuse and offenses against children is actually on the rise in Canada. So the need for these child advocacy centers and the need for further efforts and legislation in that regard cannot be overstated. As far as participation goes, this bill is very much about requiring, as I said earlier, all actors within the system, including judges, to recognize the important role and rights of victims, to have not only the information but the ability to access services like victim services and child advocacy centers, the ability to enhance their participation through important appearances on sentencing with victim impact statements. I remember practicing law when, much like Mr. Deckard said earlier, victims were treated like a regular witness, and they were to give their testimony and go home. And now, through the introduction of victim impact statements, through their participation, their greater support through the wonderful work that's done by victim services across the country, their participation is more meaningful, more impactful, and I think more satisfactory to them at the end, if you can say that, about having to go through the system through no fault of your own. So adding acknowledgement to the harm that has been done to them, having greater affirmation of their importance in the system is all part of what this bill is aimed to accomplish. I mentioned something, and it should never be seen as trivial, to be able to bring a photograph of your loved one and to be able to express personally how this crime impacted you and those around you is significant. And courts and our entire justice system have to recognize and embrace that change. That's what this bill, I hope, will accomplish. It will entrench that type of culture shift towards victims and embracing and putting them very much front and center when it comes to their rights. So I really do believe that we have, through a very nonpartisan, inclusive process, moved the criminal justice system a long way. And if I might, Mr. Chair, I want to acknowledge Carol and Pam, as you did at the outset. These 2 women have done extraordinary work in the last number of years to bring this bill to fruition. It couldn't have happened without both of them.
good to know, Mr. because they're on the hot seat in the next hour.
know.
So
That's why I'm saying go easy on them.
they'll be happy that you set them up like that. That is the end of our time with the Minister. Thank you, everyone, for their questions, and thank you, Minister, for joining us for that hour. Just so you know that we've set aside the next 6 meetings as a minimum to deal with this bill. We have the witness lists are in from all the parties, and the clerk is working very hard at making sure we get everybody here. So hopefully over the next month or so, this committee will be dealing with that item. But with that, thank you. We'll suspend for about 2 minutes while we switch over our panels. Thank you very much.
Thank you, Chair.
Suspended.
Ça va quel c'est tout recevoir
ladies and gentlemen, I'm going to call this meeting back to order. It's our second hour of our review, started the review of Bill C-32. I think I said 33 by accident when the thing was buzzing in my ear on the last one. But with us for the second panel, we have a number of witnesses. We have our witnesses from the Justice Committee, which were previously introduced, or from the Justice Department, from the Department of Public Safety and Emergency Preparedness. We have Ms. Thompson's here. She's the Assistant Deputy Minister, Community Safety and Countering Crime Branch, and Mr. Cherney. Mr. Cherney, Director of Corrections Policy. From Correctional Services of Canada, it's Don Head, who is the Commissioner. He's the Head Commissioner. And then it's late. I'm sorry. It's from the Parole Board of Canada. Monsieur Claire is here, and he's the Executive Director General. And I just asked, there are actually no presentations. We can go, they're here to answer questions about C-32. So we're going to go right to questions, and I'm assuming that from the New Democratic Party, it's going to be Madame Boivin.
You are assuming right.
Oh.
And Boivin means drink wine, to stick with your head joke. But anyway. Un plaisir de vous avoir tous ici au comité, mais comme le temps...
I'm pleased to have you at the committee. Since the time goes by very quickly, 5 minutes is not enough for me to ask all the questions I'd like to ask of you. First of all, for people from Justice, Ms. Morassi and Ms. Arnott, the offenses, the criminal code, the law against crimes against humanity, war crimes, the 2.1, the Act relating to drugs and certain controlled drugs and substances acts, but there are a number of other acts that are not included in the Victims' Bill of Rights. Why does this not apply to the Competition Act, for example? I'm thinking, for example, of fraud or telemarketing. There are victims, increasing number of victims. Why would it not apply? Why did you choose to set aside, for example, the issue of national defense, when we know that there are offenses? I don't know whether there are many, but there are certainly offenses. It would appear to be a special regime. Victims would be second-class victims, would they? This is my first question for you. Thank you for your question, Madame Boivin. First of all, I'll deal with the issue of application. We decided to choose the acts mentioned in the bill because they are offenses. The offenses included in this legislation are the ones that result in most of the victimization cases of victimization that we see in Canada. As the Minister explained, this is a first step. This is a first step forward for Canada, and based on our analysis, we could pass this legislation and deal with the great majority of the victims in Canada. You did not attempt to deal with the totality of victims. Would this not create a type of second-class victim, so to speak? This is not our view. We thought that if it were to apply to the entire federal legislation, our view was that this would be a first step. We would be dealing with the great majority of victims in Canada. When it comes to the application to the military justice system, we are working in close cooperation with our colleagues at National Defense. Their system is certainly a distinct one for various reasons. And in the amount of time that we had to prepare this bill, we were not in a position to deal with the military situation, but we are working on it, or they are working on it. In the second reading debate, the Minister talked about the fact that this would be a quasi-constitutional bill. Could you explain to us, particularly for people who may be listening, what exactly does this mean, how it will apply, and what type of precedent does it have over others? Is it over real Charter of Rights and Freedoms? How will all of this be interpreted? Yes, I'd be happy to try and explain. The term quasi-constitutional means that the government considers this to be a bill that codifies and includes values and principles that have a certain primacy in Canadian society. The other law that would have this type of statute is the Law on Privacy and Human Rights, the Official Languages Act as well. This is why in Clause 19 we say that whenever there is a conflict between a bill, the Victims' Charter of Rights, and other quasi-constitutional acts, the courts will have to ensure that the values are given proper balance. Can you give me an example of this? Can you give me an example of a type of context where this might apply? Certainly. I'll give you the example of official languages. An offender may request, for example, that a hearing be held in his language, either English or French, and a victim wishes to present a victim's statement in the other language. The right to present a victim's impact statement and the right to have the hearing. We are under Clause 19, we ask the court to consider these two fundamental rights and to ensure that there is appropriate balance. It would not necessarily involve meaning that the Official Languages Act would not be respected, but it would simply be a matter of having interpretation services provided, for example, to accommodate both. Because I understood that a certain primacy was given here, which meant that certain other rights might be taken away. But you were saying no, simply courts are directed to attempt to give appropriate consideration to these two factors. Yes, what I'd like to make as a clarification is that when we are talking about statutes, quasi-constitutional legislation, when other federal acts apply, the bill has primacy, the Bill of Rights. I would like to have an example to have a better understanding of this. If you can give us another example, I'd be quite happy. You would send it.
Party is Mr. Decker, and I encourage all committee members to, if you have questions for specific witnesses, let them know who you're actually asking. Thank you very much. Time's yours.
Thank you, Mr. Chair, and thanks to each of our officials for being here today. I just want to say I'm always very impressed with the quality of the professionalism of our public servants and officials that appear before our committee, and I want to thank each of you for the good work you do every day on behalf of Canadians. My first question is to Ms. Morency. It's good to see you again. I know that you worked very significantly on the Victims' Bill of Rights. And when the Victims' Bill of Rights was being considered, a number of victims groups mentioned that they would like to see victims have some kind of standing in criminal court proceedings, perhaps to be able to participate in plea bargain discussions, things of that nature. I wonder if you could tell us what problems, if any, you saw in granting such standing to victims, and what impact would it have, and what would the positions have been of the provinces if something like that had been included?
Thank you for the question. So, as the Minister said in his remarks, the question of standing is something that's quite victims do not currently have standing in a criminal process, and to provide victims with standing would be to essentially introduce a whole new party to the process. So right now the criminal process is the state and the offender, and the Crown represents the victim, the state at large. And one of the concerns, and it's true as the Minister said, that some victims or organizations representing victims were supportive of receiving standing throughout the criminal justice process. But many victims also said that they didn't want to cause upset to the overall system, cause further delays, and impede the efficiency of the process. And so that was one of the considerations that, as the Minister said, taken into account. That was a challenge. But was there a different way to achieve the voice that victims were asking for to be represented throughout the system? And I think that's the measures that some of the measures that the minister mentioned in terms of having victims have a stronger voice through the victim impact statement, community impact statement, having a required Crown to take reasonable steps to consult with victims before a plea is accepted. So there's the balance that the bill seeks to achieve is to recognize at the heart of the victims who are seeking standing to say, is there a different way to achieve this, and in a way that won't upset or impede the efficiency of the system?
Thank you very much. My next question, Mr. Chair, would be to the Department of Public Safety, and either Ms. Thompson or Mr. Cherney, whoever wishes to answer. The Victims' Bill of Rights contains rights to information. A lot of what we heard through the consultation process, and just generally hear from victims of crime all the time, and we heard it from the families of victims of Indigenous violence against Indigenous women at that committee's proceedings, that a terrible assault, some other kind of crime is committed on a person or a family member of an individual, and they make a statement to the police, and they hear nothing further about the case until maybe somebody is charged, and they'll find out that, and then they'll find out maybe when there's a trial. But I wonder if you could talk about the provisions of the Victims' Bill of Rights, which will provide more information to victims about the process from the day the investigation starts to the end of the trial process.
Thank you for the question. I'll start and invite Mr. Cherney to add anything to my remarks. Certainly, with respect to the investigation, the victim will have a right to have information with respect to the ongoing investigation. Again, as Ms. Morency said, not to impede in any way the investigation. There is always the independence of the police, but they will have a right to be kept informed of the investigation. With respect to an offender serving a sentence, they will have a right to have information on the progress of the offender with respect to their correctional plan, so programming that they're following, progress that they're making, for example. Also, they will have a right to be informed of mediation, victim offender mediation services that are available through Correctional Services Canada. They will also, as the Minister said a few moments ago, they will have a right when an offender is released to have access through a secure portal of a recent photograph of the offender, assuming there are no public safety risks to disclosing information 14 days prior to the release of the offender. They will have a right to have information with respect to the date, the location, and any conditions on the release of the offender. As well, they will have a right with respect to the parole hearing. They will have a right to present a statement, have a right also to designate an official to receive information for them, and they will automatically receive a copy of the parole decision as well.
Not much to add beyond that. Ms. Thompson was pretty comprehensive. I would just say, as the Minister alluded to in his remarks, the intent of the Victims' Bill of Rights really is to build on a pretty strong, solid foundation that already exists. And I would say within the Corrections and Conditional Release Act, as it stands right now, there is a wide range of information that is disclosable to victims. And so we were quite conscientious as we were drafting the bill to think about what else could we provide to victims? What other kinds of information are they looking for? And so we did pay very close attention during the consultations to anything else that we could think to add into the Act. So as Ms. Thompson said, that includes things like a photograph of the offender. We will make mandatory the release of information related to date, destination of release, victim offender mediation. So I would just say we're really building on a pretty good foundation.
Okay, thank you very much. Thank you for those questions and answers. Our next questioner from the Liberal Party, Mr. Scarpelage.
Thank you very much, and it's a pleasure to be here. Actually, I'm not a regular member of this committee, but I spoke on the bill at second or third reading few months back.
Why would we be here?
It's been a long day, Mr. Speaker. I'm calling you Mr. Speaker. It's been a long day. A second reading, of course. I just have a few questions. You mentioned the right of the victim to a whole list of things, Mr. Cherney, and I recall meeting a victim in my office a few years back, and you know, he was very concerned about the release or the whereabouts of the offender, and he seemed to know what was going on more or less. He seemed to know that the offender had been transferred to another penitentiary. He seemed to know that, if I recall correctly, he seemed to know that the offender maybe wasn't necessarily embracing his correctional plan. So up until now, has it been more of a hit and miss thing, or there just hasn't been a consistent release of you know, information? Is that what this bill accomplished? It kind of codified certain things and made sure there was a consistency where before, you know, it really depended on circumstances or province or what have you. Is that what you were saying when you said the bill builds on a good foundation already?
Indeed. I would say that the legislation as it's crafted right now with respect to the release of information to victims really does err on the side of disclosure to victims. So unless there's a reason, a credible reason not to provide that information, where there's some clear evidence that disclosing that information would somehow impair public safety. But I would certainly say that I'm not sure that the track record has been hit and miss, but I think the VBR will certainly emphasize for all federal departments and agencies to always be mindful of the place of the victim and the imperative to, as much as possible, to disclose information when it's requested. And I think it probably certainly will bring more consistency.
So it's more specific in terms of the information that must be disclosed if asked for than currently is the case. Am I correct in my understanding? It's, you know, it's very specific as to, well, you know, you have to provide this if they ask for it, whereas before maybe it was more of a policy issue or.
As it exists right now in the CCRA, there are two categories of information. So there is what we call the mandatory class of information that must be disclosed to the victim, and that is generally already public information, so information that would have already been available through the trial process, for instance, so the name of the offender, the location of the penitentiary where they're serving their sentence. And the second category is what we refer to as the discretionary category of information that may be disclosed to the victim. And that's a little bit of a longer list of information that may be disclosed at the discretion of the commissioner or the chairperson of the parole board. And it's that second category of information that is subject to a privacy test to ensure that releasing that information is made on a case-by-case basis, and that it is always appropriate to do so in the instant case. But I would certainly say that this bill will certainly strengthen those measures in ensuring that requests for information are always going to be treated on a case-by-case basis, but the onus will always veer towards disclosure.
I see. Now, there was another point you made that I didn't quite understand, and it was actually in response to a question from Madame Boivin, that two classes of victims, this doesn't cover all classes of victims. I didn't quite understand that. I was wondering if you could elaborate for me.
Mm-hmm. So if I can paraphrase what Madame Boivin was asking, she was asking why the bill only applies to a listed number of federal statutes, and that if by implication a person was a victim of another federal statute, was this legislation creating different classes of victims, some victims with more rights than others? If I can be so bold as to paraphrase for you, Madame Boivin.
What kind of victim would not be covered? Just, do you have an example of?
Yes. So a victim of an offense under the Transportation Act, or under an Environmental Protection Act.
Okay, yeah,
This bill is focusing on victims of crime, and as I mentioned, it was our view that we were capturing the vast majority of offenses which created victimization.
Right.
One more question, sir.
One more question. Yep. On the issue of standing, in the United States, I believe that the victim has a right to have a say in the sentencing. Not a right to have a say, but a right to, well, to have a say. But obviously, the judge or would decide. But is that correct? Is my understanding correct? The victim actually can intervene at that level, whereas here it would be limited to victim impact statements, which of course is important. Is that a correct understanding?
In the U.S., there are a limited number of states, so it's 8 of 50 is my understanding, that have some form of standing for victims of some offenses at some opportunities. And I'm sorry to be so vague.
They have to have their say in sentencing, or have their say in what specifically?
I don't have that information with you.
Yeah, that's fine.
That's it. Thank you. Thank you for those questions and answers. Our next question from the Conservative Party is Mr. Wilkes.
Thank you very much, Chair, and thank the witnesses for being here. My questions are directed to Ms. Morency or Ms. Arnold, and I wanted to raise the issue with regards to identity protection, and with respect to the accused's right to make full answer and defense under Section 7 and 11D of the Charter of Rights and Freedoms. And it's a 4-part question, so I'll just ask the questions and then you can just fly at it and I'll be quiet. So, with regards to Section 7 and 11D of the Canadian Charter of Rights and Freedoms, particularly where the identity of the witness is not disclosed to the accused, is this why Section 12 of the Canadian Victim Bill of Rights would provide for requests to be made for the protection of the identity of the victims, complainants, or witnesses, rather than for orders to be automatically granted upon such requests being made? The second question, who would be the decision maker where a victim has requested that his or her identity be protected? The third question, on what basis would a decision maker consider whether to take measures to protect the identification of the victim? And fourth, would the police and security intelligence agencies know in advance whether anonymous testimony would be allowed and be in a position to give assurances to a witness that he or she would ultimately be permitted by a court to testify anonymously?
So I'll try to take the questions in order, but the way the Bill C-32 is proposing amendments to permit some victims to be able to, or witnesses to testify through a pseudonym. Right now, that ability exists, but it's not codified, it's not in the criminal code, and the courts have made, some courts have made the decision, depending on the facts and circumstances, to allow a particular witness to do so. So I can give you an example. In a 2002 decision of Musso, there was a victim who, in a sexual assault case, who was concerned. There were a number of other victims. Apparently the accused was believed to be harassing some of the other complainants, and because he knew their names, was alleged to be engaging in those kinds of communications. This last victim, complainant, who was testifying in the proceeding, did not wish to be exposed to the same kind of harassment communications. So in that case, the court determined that the witness could testify through a pseudonym. The jury wasn't provided with, didn't know that that's how the victim was testifying. But basically in that case, the court is always going to have to consider the facts and circumstances. And so the test that would be applied now under the VBR would be the same as what the courts are doing in practice right now. So they'll look at, in terms of the importance of a defendant's charter right of the defendant to be able to make full answer in defense, proper administration of justice, principle of open court. The court can take a number of steps in making, it's going to be the court that will make the decision, And the court can take a decision based on a consideration of all of those factors, and what measures could be taken that will secure, safeguard the accused's right to make full answer in defense. Could the victim testify through pseudonym and also through, for example, use of testimonial aid where the victim, the complainant can still see the accused can still see the witness complainant. And it's going to be the court in the circumstances that's going to take a decision. What measures are needed to enable that victim in that situation to testify through the use of a pseudonym and yet still protect the right of the accused to make full answer in defense? Sorry.
I can get you another question.
And because the decision maker would be the court, it wouldn't be possible to know with certainty in advance, but what would happen is that the victim or the complainant would make the request through the Crown, and the court would be able to make the determination.
Okay. If I can, 1 minute. 1 minute. So if I can just change gears quickly with regards to spousal competency and compellability rules. C32 proposes amendments that would create a general rule of witness competency and compellability whereby the common law rule of spousal incompetence would be eliminated and spouses would be competent and compellable by the prosecution to testify against their spouses. However, spousal privilege under Section 4 sub 3 of the Canadian Evidence Act would remain. So a husband would continue to be uncompellable to disclose communications made by his wife during the marriage and vice versa. Would these rules still apply to common law spouses?
So currently, we have a mix of statutory provisions that protect against compellability for spouses, and also some common law rules. So these are in the Canada Evidence Act. The bill is seeking to abolish that rule so that all spouses would be competent to testify against their spouse and compellable. And right now, common law, it does apply. For example, in the situation of a spousal abuse situation, that would be covered now under common law. So yes, it would still apply in that sense. So basically what will happen is the Crown would make a decision in a particular case. Would calling this spouse to testify against the accused provide evidence that the Crown cannot otherwise bring before the court? And the Crown would normally take into consideration, are there other sources of evidence that to be able to provide that? And if not, then if that's the major witness, then that would be an option. So, for example, an impaired driving case, the spouse who sees the accused driving would be able to say what she observed her spouse to be doing, but she would not be required under the Victims' Bill of Rights to communicate what had been communicated to her in confidence by her spouse. So the communication privilege would be preserved by Bill C-32, but she could still be compelled to testify as to her own observation.
Okay, thank you very much. Thank you for those questions. Thanks for those answers. Our next question from the New Democratic Party is Mr. Toon.
Merci, Monsieur le Président. Puis merci pour les témoins.
Thank you, Chairman. I'd like to thank the witnesses. A very interesting presentation or answers. This is a point that was raised by the Minister himself during his testimony, and I'd also like to talk about the fact that under Canada Evidence Act, Section 43A, references made to couples of different sex. In Canada, we have a legal marriage of couples of the same sex. And I would like to quote it in English because, of course, it is the English version that does pose a bit of a problem.
Any communication made to him by his wife during their marriage, and no wife is compellable to disclose any communication made to her by her husband during their marriage. Le projet de loi qu'on a devant nous.
The bill that we have before us doesn't seem to deal with this inconsistency, the Charter of Rights and Freedoms, and the reading in of the Supreme Court. It appears to me that there might be a constitutional problem. Do you have any comments to make on that?
And it is actually an issue that's currently being litigated before some of the courts. Bill C-32 is not addressing that other broader consideration, but it is looking to make the evidence of any spouse available. So it is a matter that's before the courts.
Et même si c'est devant les tribunaux.
Even though it may be before the courts, would it not be possible for us to make the correction today?
Well, seeing as the minister isn't here right now, I was hoping that maybe one of you could answer it. I see. All right. So we're back to.
Doesn't work that way.
We're back at question period then, I guess. Quality. Sorry about that, but.
Well, that really wasn't fair, Mr. Toon. The officials are here to answer questions that they're entitled to answer. If there's a question that should have been asked of the minister, they will often tell us that that is not of their purview or their responsibility to answer. That has nothing to do with them not willing to answer or willing to. It is their legal responsibility, and that is what they're withholding. So I think that wasn't quite fair to the
Very
officials.
good, Mr. Chair. Alors, si on continue, peut-être sur une autre question plus.
To continue, perhaps another more pernicious matter. Clause 3. The Clause 3 of the proposed Bill of Rights. In the French text, it would appear to be more restrictive than the English version, and I would like to hear what your comments on this. In the French version, only one individual is authorized to act on behalf of the victim when the victim is either deceased or unable to act for himself or herself, or incapacitated. In the English version, it would appear that there is authorization to give any of the following individuals. So the French is more restrictive. Do you have any comments on this? Thank you for the question. This isn't the way that I would read the bill, even though I can see that it might be liable to this interpretation. Our intention in this provision is that among the various people listed, any of these persons may be able to act as a representative of a victim if the victim is deceased or is unable to act on his or her behalf for him. So the idea then is to indicate that it may be from a larger group than. In the Department of Justice, I should note that we do analyze, conduct a juridical and bilingual analysis of the. I think that the intention is quite clear, and I think that this is the important matter then.
Wide question then. The proposed Bill of Rights speaks often of rights. I mean, we're talking about rights. We're not really. It doesn't really speak of principles. It's speaking of rights. But at the same time, it doesn't create any cause of action. If somebody feels that their right has been breached, they don't seem to have any recourse. So it's a particular kind of right that we seem to be creating here. So could you explain to me what kind of rights? That maybe the question could be in this case. Are we not giving them right of recourse because it exists already at the provincial level? Is it because that jurisdictionally we're having a problem, or is it because we really didn't want to give them any recourse if we feel that the rights that we're affording in the new bill have been breached, that we really don't want them to be able to pursue, for instance, the federal government?
So I think, as the minister indicated, the intention of the government is to create enforceable rights. The choice that the government made was that those rights would be enforceable through a complaint mechanism, and the bill provides what that complaint mechanism must include. So an ability to receive the complaint, review the complaint, make recommendations, and report back to the victim. This bill differs quite significantly from provincial and territorial legislation that you might be familiar with, in that the rights here are very clearly stated as rights. So provincial and territorial legislation includes languages such as victim should, government should. And so one of the key differences here that indicates the character of the rights that the government is wanting to create is that the rights are expressed that way. Victims have a right to. In regards to, and one of your colleagues has asked a question about standing, the government's view in creating, or the government's intention, I should say, in creating the complaint mechanism was that, one, it reflected what had been heard in consultations. Two, it empowers employees to make changes in their thinking and in their approach to their duties that will reflect the fact that the concerns of victims, the needs of victims should be part of the exercise of those duties.
Thank you very much for those questions and answers. Our next questioner is from the Conservative Party, Monsieur Gauguin.
Thank you, Mr. Chair. Thank you for your testimony. I know it's hard to answer a lot of these technical questions, and I suspect a number of you are lawyers, and it's always more fun to ask the question than to answer it, for sure. But in any event, I'm looking at Section 9 of the Canadian Victims' Bill of Rights, and that recognizes that all victims have the right to have their security considered by the appropriate authorities in the criminal justice system. So the question is, to what extent would the appropriate authorities be obligated to take measures to provide for the security of victims? And as a sub-question, are the Parole Board of Canada and Correctional Services of Canada appropriate authorities obligated to take these measures to provide the security of victims?
Thank you for the question. With respect to the security, for example, I would mention, and I think I made mention of the fact that the parole board will be required to impose reasonable and necessary safety conditions following a victim impact statement that highlights concerns over security. And so as provided those measures are necessary and reasonable, those would be measures such as non-contact orders or geographic restrictions, for example. And that is a requirement on the parole board to go forward with those considerations if they have safety, security measures, concerns, and do not proceed with imposing such restrictions. They have to make sure that they provide that in writing. I don't know if the Commissioner would like to respond on behalf of
Sure, thank you. Just a couple of points to add. We have victims who come into our institutions now to attend parole board hearings, and one of the things that we're very conscious of is their safety and security while they're in their institution. So we have a good track record around the protection of the physical protection of victims, but also providing emotional support for them as well, because as you can well imagine, walking into that kind of environment and facing somebody who has committed harm to you can result in significant emotional reaction. So we also have that kind of support. And as was pointed out, in terms of individuals out in the community, decisions that are made by our wardens of the institutions have to take into account any issues raised by the victims regarding their safety in terms of decisions they may be able to make around escorted temporary absences or even unescorted temporary absences. And in addition, we'll be looking as we go forward how we can use technology to help enhance our ability to monitor offenders who may be out in the community under conditional release, so that if they have the kind of geographic restrictions that we can stay on top of that and ultimately provide the safety and security that victims are looking for from us.
Thank you. There was talk earlier about mediation, and one can imagine how difficult it would be for someone who's a victim to, I guess, confront their accused, but there seems to be more and more demand for the mediation services. And victims do not automatically receive information about the offenders who harm them. I guess they have to submit a written request to Correctional Services Canada or the Parole Board. I'm wondering about victims who have just submitted a general request for information to the Corrections Services or Parole Board. Will they be advised if they've just submitted a general sort of a request about the availability of victim or mediation services? Excuse me.
Yes. So we're going to, as an organization, we're going to be proactive in that regard. We currently have about just over 4,000 registered, over 7,700 registered victims in relation to about 4,000 offenders. And through our victim service officers, we have been advising them of the opportunities for victim offender mediation, for restorative justice opportunities. So we're going to continue to pursue that proactively and allow them to be aware of the kinds of services that that can be made available and that they may want to access. So this is one that we're going to be out in front. And with the work that we're going to be doing jointly with the Parole Board of Canada in terms of creating a web portal, that information will also be available to them on the net.
Parole Board of Canada doesn't provide mediation. That's a service provided by the Correctional Services of Canada. We have about the same number of registered victims. We have over 7,500, and we have specialized staff like the Correctional Service of Canada cross country that provides information to the victims. So whatever information we can disclose or may disclose, we do. So not everybody wants to attend a parole board hearing. Last year we had about 250 people attending. So we can provide them information if they request it.
That's good. Okay, thank you for those questions. Thank you for those answers. Our next question from the New Democratic Party, Madame Aubin.
Merci. Mes questions.
Thank you. My questions will be in relation to the surcharge, this compensatory surcharge that is provided in section or clause 31, I think. The changes that are proposed in this respect can you tell us whether their purpose is to respond to what the courts have before them right now, that is certain challenges in the way to pay? I'd like to know whether you think that this is going to have an impact on cases that are now before the courts, the Court of Appeal in Quebec, for example, and various other courts. And when you use the term unreasonable delay, an unreasonable time period, is it a matter of the discretion of the court? I'm attempting to understand what exactly is meant by this provision. There are approximately 30 different cases dealing with the application of this surcharge or fine. The provision mentioned here deals only with the payment within a reasonable period of time. The challenges deal not only with this matter, but the ability of the offender to pay this fine. As far as the time period is concerned, we have proposed a number of amendments to clarify the courts that payment cannot be spread out over tens or hundreds of years, which was a decision of a number of courts. Are you sure that this is the way it will be interpreted, rather than codifying, so to speak, in the law? Did the courts come to the conclusion that reasonable periods of time were to be provided? Because a reasonable period of time, when I looked at this, I'm not sure that this is going to be a way of dealing with the problem, because it's opening perhaps another can of worms. The courts will say the legislator is speaking through the 31 and realize that we were not too hesitant to use this fine when we're dealing with a person who may not be unable to pay this amount. But when we're talking about $100 or $200, it might represent a significant amount for certain people. What actually leads you to believe that you were dealing with the problem? The term "a reasonable period of time" is to be found within 9 acts at the present time, and we looked at the legal interpretation given to this, the factors that the courts take into account in defining this concept, the particular circumstances of the party. The period is meant to be a reasonable period in which the offender does have the actual possibility of paying off the debt. So I would say that this is a fairly well-established interpretation. There are cases that go back to the 1920s on the interpretation of this concept. So in this context, do you think that the tribunals or the courts would be able to extend these time periods? Do you not think that they are more likely to use this? Because according to what you say, the individual circumstances was what the judges used as an argument when they said that it could be paid over 100 months. I can remember that one case, it was a very long period. And in my view, this decision was certainly well argued. It took into account the circumstances as well as the various criteria you mentioned. So it seems to me that the government was taking a note of the fact that there is a problem. There's a problem then in the courts. What I would say, and I know which particular cases you are mentioning or you're referring to, the problem was that the offender was asked to pay a certain number of cents per day for hundreds of years. This, of course, is not in keeping with the purpose of this fine, and the purpose being, of course, a contribution to victim services. A few cents a day, and in fact, it does not amount to a reasonable punishment. And the amendment that you are making here to this article on the this extra fine, you think that they will deal with the problems that are faced by the courts? Yes, this amendment does qualify the intentions of the legislator with respect to this particular issue. When it comes to 739.1 of the Criminal Code, the financial ability of the offender to pay would not prevent the court from making a restitution order. Did you carry out the review of case law, and does it meet the criteria set out by the Supreme Court when it comes to such matters? This means that you do away with the notion of the ability to pay. This is not taken into account. What about people who cannot pay? Are they thrown into prison? This factor is not the single one. It is not the determining factor in the court's decision to order a restitution payment. It is one of the factors, but it is not the determining factor. It is simply a codification of decisions that were taken by the courts of appeal in various provinces, and decisions that go back for a number of years now. So basically what you're telling me is that they will continue, courts will still be able to deal with the ability to pay. It will not be the only criterion. Thank you.
I'd just like to say, I know Mr. Decker thanked each and every for your work you do as civil servants, but you are from the Department of Justice, the Department of Public Safety and Emergency Preparedness, Correctional Services, or Correctional Service of Canada, and the Parole Board of Canada, all doing, so please pass on to your colleagues and those who work in those departments that we appreciate the work, the civil service that you do. Some of those areas are very tough areas to be working in, and we really appreciate the effort that each and every one of our civil service do. And you don't get too many thanks, and at our level, we don't get to meet too many people who actually do the work for the Government of Canada. So on behalf of the Justice Committee, we want to thank you for all that. With that, we'll adjourn, and happy Thanksgiving, everyone.